Good morning, Miss Moss. Ma'am, you were charged with theft. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Welcome to Hot Law. Up next, we follow a gripping armed robbery hearing in a U.S. court where a woman named Moss is facing serious charges. Prosecutors say she was forced to conspire with another suspect to steal a mere $186 worth of goods from Carter's store. Now the big questions: will Ms. Moss be sentenced to 6 months in jail and fined $2,000? What's the true relationship between her and her juvenile accomplice? Stay with me as we track the latest developments in this unfolding case.
Yes, Judge. On February 13th, officers responded to a theft call at the Carters located at 1257 West Bay Area Boulevard. Dispatch advised that one female, the co-defendant, was concealing items in a bag and underneath her sweatshirt, while the other female, the defendant, was handing items. Claiming witness stated that the females were walking out of the store past all points of sale. Officers located both females walking out of the store located on the sidewalk next to the store, traveling west on foot. The co-defendant attempted to ditch the clothes where she threw them on the ground. Both females were detained. The co-defendant was identified as a juvenile. The complaining witness provided video footage of the theft, and the total of the merchandise stolen was $186.
Okay. Do you have the co-defendant? Do we have that person here? Do you know? Do you have a cause number?
It's a juvenile, Judge.
Juvenile.
I believe that they would be in.
Okay. All right, Ms. Moss, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to go to any Carters. Do you understand? You were on bond for another case, and now you've picked up a new case. Really, at some point, we're going to just revoke the bonds and make them high. If you're a danger to the public, there's only one place that we have. Do you understand, Ms. Moss? Did you want to apply for a court-appointed lawyer, ma'am? Okay. Do you mind filing no going to any Carters, please? And who is the co-defendant? Like, do you have a relation? Because I'm going to order no contact with that person.
Let's see, Judge, if I can find it.
Whatever.
I just have the identifying information, the initials IM. I believe she's 15 years old.
Is there, or did they list a relation of some sort? Do you know?
I don't see it on the Denver, Your Honor. We don't have the evidence report back yet.
I guess we'll wait and let me see. So for now, ma'am, I'm going to have you sign a receipt with Victoria. I need you to fill in an application for me, and then we'll have you take a seat in the jury box. Do not leave until you sign our bond conditions. Do you understand? Okay, please. Deputy Manager, would you?
Yes, sir. How you doing this morning? I apologize for being late.
It's okay. I'm
Yes,
glad
sir.
you made it.
I'm just glad I was able to call and let you know because I was gonna come, no matter if I had to start
You're here now.
walking.
That's what matters.
Yes, sir. Amen.
Tell me your last name again.
Gary, Gary. My name.
Stop. Don't, please. You have the right to remain silent. Exercise that right. I have a bunch of DAs here, and whatever you say, that they can try to use it against you. So that just...
We now turn to a disturbing trial in the spotlight. A woman named Gary stands accused of assaulting her boyfriend. Early testimony paints a chilling scene. What began as a quiet conversation escalated into shocking violence, with visible scratches and bruises on the victim's body. The big question looms: how will the judge rule? The stakes are high. A felony assault conviction could mean up to 1 year in prison and a $4,000 fine. Is Gary truly responsible for this serious offense? Stay with us as we uncover the details behind this dramatic courtroom hearing.
We'll talk here momentarily, and then I'll let you get out. But I just don't want you to say something that hurts you, you know? So, Ms. Gary, you're charged with assault of a family member. You are facing up to 1 year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
On February 16th, 2025, within Harris County, Texas, officers were dispatched to a disturbance. The officers made contact with the defendant, who stated that she and the complainant were in a dating relationship. The defendant stated that she and the complainant were in a verbal argument when she stated that she did not like his comments, and the defendant stated that she assaulted him by punching, biting, and scratching him. The complainant stated that there was a physical altercation and that his injuries were in fact from the defendant. The officer observed several scratches, bite marks, and bruises on the complainant's body.
What is the relationship? Do you know?
They were in a jaded relationship since October 1st, 2024.
Okay, so Ms. Gary, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond. Well, what I'm going to do is I'm granting a protective order. This is a protective order that identifies Mr. O'Banion as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand? This is a very serious court order that if you violate, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. So just don't. Now, would you like me to provide you with a lawyer? Okay, I will give you a lawyer today. Everything that you wanted to tell me, tell it to the lawyer, and then they can, if need be, come and talk to me and we can try to resolve any issues that may come. I'm afraid of what you would say to me. They're going to hear it. It's probably not a good thing, you know? Do you have any other questions?
I can go to jail for a year.
That's the potential punishment in this type of case. It's up to a year in jail and or a $4,000 fine. That is an assault. And this type of assault.
Yes, sir.
So, but that doesn't mean it's going to happen, you know? It just, the potential, that's all.
Yes, sir.
So I need you to fill out an application for me though. So Deputy Echegoyen is going to give you an application. I just need you to fill it out. Do not leave until you sign our bond conditions, and then I'll have you talk to a lawyer here.
So am I still, do I have to pay anything on the PR bond?
No,
Okay, thank
not paying
you.
anything.
Thank you. Oh, well, they said I had a $90 court fee.
Don't listen to them.
God bless you, sir.
Good morning, Mr. Murdoch. Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Breaking news from a U.S. courthouse. Today, we turn our attention to the drunk driving trial of Mr. Murdoch. The case began when officers noticed his vehicle acting suspiciously near an after-hours bar, including an illegal U-turn. A breathalyzer later revealed blood alcohol levels of 0.112 and 0.109 SLA, both above the legal limit. In a swift move, the judge denied all enhancements and immediately suspended Mr. Murdoch's license. The possible penalty, 6 months in jail and a $2,000 fine. Will Mr. Murdoch be held accountable for his reckless decision? Stay tuned as we track the next tense developments in this unfolding case.
On February 16th, officers observed a blue Kia Forte at 6300 Antoine Drive. The officers observed the vehicle make a U-turn where there's a prohibited U-turn sign. A traffic stop was initiated. Officers had previously observed this vehicle pulling out of a known after-hours bar located at 6314 Antoine Drive, Harris County, Texas. The defendant was a driver. Officers observed slow-speed, bloodshot eyes, and a strong odor of alcoholic beverage. The defendant admitted to drinking 2 Bud Lights. Standard field sobriety tests were performed. 6 out of 6 HGN, 1 out of 4 one-leg stand, and 4 out of 8 walking turn. The officer observed a 12-ounce Bud Light bottle of beer that was open and about 3/4 full upon an injury.
Drinking in the car while driving.
There were also 2 unopened shooters tequila and meal console. The defendant consented to breath. TAC came back as 0.112 and 0.109.
I missed the basis for the stop. Can you tell me that one more time?
They saw the vehicle perform a U-turn in an area where the U-turn was prohibited.
Okay. Mr. Murdoch, I'm going to find that there's probable cause to go forward with your case. I would figure that it was damn elementary that you're not to have alcohol in the car while you're driving. I am now taking away your privilege to drive. You were not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. And I don't give a rat's behind what your excuse is if there's a burning building and you have to save 50 children. Do you understand? Every time you drive, it's punishable by up to 6 months in jail and a $500 fine every time you drive. Mr. Murdoch, I'm ordering you as a condition of your bond not to consume alcohol illegal drugs, or unprescribed controlled medication, I'm going to randomly test you if I find that you're using. Likewise, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? Do you have the ability to hire a lawyer, sir? I'll have you fill out an application. I'll see whether you qualify. Heed this warning, Mr. Murdoch. You will not get another one. Do not become a danger to my city. All right. Mr. Fleischer, you're charged with burglary of a motor vehicle. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The case began with a backpack theft at the workplace of two unsuspecting victims, but the twist, one of their mobile phones was later used to transfer $400 via Cash App, directly tied to the main report. From that transaction, investigators traced and positively identified Mr. Fleischer through his social media activity. In response, the judge issued a stern order banning Mr. Fleischer from using alcohol and illegal drugs and warning of increased custody if he violates the law again. The question now, can Mr. Fleischer prove his innocence in court? Stay tuned for the next developments in this evolving courtroom drama.
Officers were dispatched to burglary of a motor vehicle. The complaining witness Hargrove and complaining witness Vargas stated that their backpacks were stolen from their work truck. They stated that their vehicle was unlocked. A witness was able to provide ring camera footage showing a suspect walking across the street to the vehicle. A few minutes afterwards, it was found that complaining witness Hargrove's phone was used to send $400 via Cash App from the complaining witness Hargroves to the defendant. Officers were able to use this transaction to get a picture of the defendant through the Cash App. The complaining witness Hargroves sent this photo to a cousin and said that a friend knew the defendant from high school. Officers looked on social media sites and matched the pictures to the Cash App account.
Okay. Mr. Fleischer, so you also had a theft case. I didn't realize. So you're charged with theft. You're also charged with burglary of a motor vehicle. I'm going to find that there's probable cause to go forward on both of your cases. When was this? Was this in the middle of the night?
Sorry, George, 2:23.
So 2:22 in the afternoon. Okay. Mr. Fleischer, I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand? I'm going to do everything in my power to protect every single person of Harris County. And if that means making you bond really high and putting you in custody, I'm going to do it in a heartbeat. Do you understand? Yes or no?
Yes.
How old are you, sir?
I work at a nursing home. Work at a nursing home.
So you do work.
Yes.
You want to apply for an appointed lawyer, sir? Okay. Deputy Miranda is going to give you an application for an appointed lawyer. I'm going to have you supervised. You're not to be in possession of any weapons as well. Do you understand? I'm telling you, behave yourself while you're out there in the free world, because if you don't, the free world will be taken from you. Mr. Fleischer, I think that you make too much money to have a court-appointed lawyer. Do you not, where do you live at home with mom or dad, or who do you live with? Yeah, I mean, you make a lot of money and you have literally no expenses, so I can't really give you one. So what we'll do is we'll give you time to hire a lawyer, and then we'll have you sign a reset. There's a gajillion and one lawyers out there. It's getting on the phone, interviewing one, finding one that you like. 99% of lawyers will put you on a payment plan as you go. So you just a couple $100 here, there, however, like anything in life, you get what you pay for though, right? They're the Mercedes-Benz of lawyers, and then you got the Yugo of lawyers. So just be careful, all right? Don't be a danger to my city, man. You know what I mean? Really. All right, come on. Oh, he already? So I guess we need him to sign conditions.
Right, so they'll just
Okay, yeah, just take seat. We'll have two conditions, then you get it again, and you're gone. Good morning, Ms. Wells.
Yes, sir. Hi.
Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
In this case, Ms. Wells is facing a DUI charge, a serious offence made worse by her extremely high blood alcohol content. According to the traffic department, Miss Wells was seen driving dangerously, causing collisions with other vehicles on the road. The results? Her alcohol level tested at a staggering SNAR 0.296 and 0.297, nearly 3 times the legal limit. The judge refrained from issuing any additional warnings, but emphasized the harsh consequences for repeat offenses. This charge could bring up to 1 year in jail and a $4,000 fine. The question now, will Ms. Wells recognize the gravity of her actions and change course? Stay with us as we track the next developments in this high-stakes hearing.
On February 15th, officers were dispatched by the Harris County Transit Authority dispatch to a reckless driver in the 5200 block of South San Houston Tollway. Officers observed the vehicle fail to maintain a single lane and nearly strike 3 different vehicles. A traffic stop was initiated. Officer observed slurred speech and disheveled clothing. The defendant admitted to drinking. SFSTs were performed. 6 out of 6 speech began with vertical nystagmus. Officer was not able to conduct the walking turn from the one-leg stand due to being unable to maintain her balance. Defendant consented to breath, came back as a .296 and .297.
Any prior DWIs? Ms. Wells, I'm going to find that there's probable cause to go forward with the case. Can you run your license as well, please? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you consume anything, I'm going to revoke your bond and put you in jail. Do you understand?
Yes, sir.
If you have a problem with drugs or alcohol, now is the time to address it, because if it becomes an issue, I'm going to do it for you. And I promise you're not going to like the way that I do it. Do you understand?
It's about the drugs.
Okay, you are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. If you don't have car insurance, you may not drive. Do you understand? Okay. Tell me, do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify for an appointed lawyer. If you do, then we'll appoint you someone. For now, I'm going to have you meet with Victoria. We'll have you sign a reset. You'll eventually get with Fleischer your bond conditions, and then Deputy Miranda will give you an application. Good morning, Mr. Guzman. Sir, you're charged with criminal trespass. You're facing up to a year in jail because of the deadly weapon paragraph. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Mr. Guzman is now facing a charge of criminal mischief, made even more serious by the involvement of a deadly weapon. The incident took place outside a store where Guzman allegedly attempted to stab a man with a knife in the parking lot after being asked to leave by an employee. Though Mr. Guzman claims it was self-defense, character testimony is now being debated in a different forum. The judge acknowledged Guzman's good fortune in not facing additional felony charges, but delivered a clear order: do not return to the scene and do not possess any weapons. This case is far from over. Stay with us for the next major developments from this courtroom hearing.
On February 2nd, 2025, at approximately 5:30 p.m., officer was dispatched to 1201 Spencer Highway in Harris County, Texas, for criminal trespass. Upon arrival, officers made contact with the complaining witness, who stated that the defendant attempted to stab him with a knife in the parking lot. Officers attempted to make contact with the defendant, and the defendant began running north through a strip center and tried to hide behind the strip center. Officers told the defendant to get on the ground, and he continued to walk toward officers and refused to take his hands out of his pocket. The defendant was arrested. Officers retraced the defendant's path and located a knife. The defendant admitted to having the knife and stated several males tried to jump him in the parking lot. The defendant stated one male tried to stab him and he was defending himself. Officers spoke to the complaining witness again. They said that he was in the store purchasing items, and the defendant was asked to leave by the employees in the store. The complaining witness stated that the defendant refused to leave and got into a verbal altercation with the employees. The defendant left, then waited outside in the parking lot and started asking people for money. The complaining witness told the defendant that employees had asked him to leave. The defendant pulled out a knife and brandished it in his hand and started walking towards the complaining witness. The complaining witness stated that there was about 25 feet between them. The witness saw the defendant walk towards the complaining witness.
So he goes back into the store after he leaves and after they told him to leave.
Yes.
Okay. Mr. Guzman, I'm going to find that there's probable cause to go forward with your case. Let me tell you that you're lucky that you're not charged with multiple felonies as well as it is, you know? I am ordering you not to be in possession of weapons and not to go back to this place. Do you understand?
Sir.
If I find that you become a danger to my community, I only have one place for you, Mr. Guzman. You know, really. I already have an affidavit and Deputy Randall. All right, so what I'm going to do is I'm going to have you go sign a receipt with Victoria. We'll have you take a seat in the jury box. I'm going to find you a lawyer here momentarily. Do not leave until you sign our bond conditions.
Sir.
You have missed court once. This is your second PR bond that they gave you. You will not get another one. If you miss court again, I'm telling you, your bond will, no more PR bonds. Do you understand?
Thank you
I'm
for,
giving you a lawyer. All you need to do is stay out of trouble. Make wise decisions.
sir, could I say,
No,
I just want
no.
to thank you for,
Just,
I called last week and I was supposed to come. I had a car problem. I didn't even think, thank you for giving me the second chance on the PR bond. You know, and I mean, it was, I called, I understand.
you're out. All I'm asking you to do is make good decisions.
Yes, sir. Yes, sir. Yes, sir. I understand, sir.
Give you a lawyer here momentarily. Just, all right, hang tight. Let me have you sign the reset and then we'll have you go back.
Thank you, sir.
All right.
All right, then, next is